So my name is Pete Snyder. I'm at Brave Software. My title is Senior Privacy Researcher, and my job is to work in web standards and to do feature design at Brave to help our users stay private online.
My name is Sebastian. I'm assistant professor of computer science at Wesleyan University, and together with Pete and Robin, we started global privacy control, and we're going to talk much more about it. But it's a really fun project, and I think a great effort.
And hi, I'm Robin Berjon. I'm VP Data Governance at the New York Times, and I mean, a large part of my job is to ensure that we offer our readers, great privacy, or as great privacy as we can in today's online business environment. And so, working on the GPC project is definitely a big part of that.
Yeah. So maybe I could imagine that many people may have heard of GPC but don't know exactly what it is. And so maybe we can give a brief introduction of that, and also maybe some of the background, right? I mean, how did we come, to work on this? And so I just give it a brief shot, and then maybe hand it over to Robin and Pete to say much more. So essentially, we are a very diverse group of publishers, browser vendors, extension developers, and tech companies and academics. In fact, the initial start of our project was really the idea of the CCPA, the California Consumer Privacy Act, that says that if you want to opt out from the selling of your personal information, you can do that using what they call global privacy controls. So, you see that's, where we got our name from. Not very creative. We discussed many other names, but, settled on that one ultimately. And so that is, the idea of the project, that we wanted to have a signal in the browsers or browser extensions, and hopefully later also in other, services, so that users can express that they do not want to have their information being sold. And, selling is understood broadly. That, for example, also means advertisers on websites would not receive, for example, location data from users. So it does not mean necessarily only just, selling in the sense of giving at the back end to data brokers, but also things like, having cookies from advertisers on the website. So that was the initial idea, and we got together and started to think about, okay, how can we make this happen? And a big part of this was that we decided to come to the W3C, and that Robin and Pete have great experience, and I'm very fortunate to learn from them about this. It's a very very nice thing that I had not experienced before, the W3 standardization process. And so that is what we're doing. But on the other side, we also try to read practical implementations. So we have template reference implementations for browser vendors, for the backend, for the server, and also for extension developers, notifying users, for example. That's, what we will also publish soon. And so maybe, I leave it at that. So that's, the basic idea. And, and maybe you can, fill in a little bit what I forgot here.
Yeah, that's a great intro. I mean, at any moment, if anyone wants to ask a question on the chat, I think go ahead. I don't know, Peter, do you want to talk about the value you see from GPC from a browser standpoint, for instance? What it could bring to Brave's users?
Yeah, absolutely. So when we're thinking about how to, we know Brave users are particularly interested in privacy, or many of them are, and so we think of our job at Brave is to two-part. One is to protect Brave users against people who are not respectful of their privacy, and one is to make it easier to interact with parties who are respectful of user privacy. And GPC is much more in the latter category. There's a large number of publishers and web participants who integrate in privacy-preserving systems and figure out how to be good web citizens and respectful of their users. And GPC is meant to be a way of communicating that wish and that desire from the user to any of the parties involved in creating a website or similar. And so the way it works at a technical level is there's something that gets sent over the network and something that's available in the websites can query when they're executing code on your page. But in general, it's a way of saying, it doesn't force any partner to do anything, but it's a way of saying, please respect whatever privacy rights that you're willing to respect. And so it really fits kind of in a lineage of do not track and other kind of related things which are not adversarial between the browser and websites, but meant to be collaborative or meant to be part of a communication or a system that touches both sides of the system. And so I see it, that's the question from Eric about do not track. They're very similar. I mean, in terms of implementation, they're very similar. They're just DOM properties that express a user wish. The hope is that
or a request header.
Or a request header, just similar to do not track too. There's it's just a request from the user to the website or the people participating in the website to respect some desires. So in that sense, they're very similar. But where they differ is that GPC is meant to integrate into what seems to be a growing number of pieces of legislation meant to protect people's rights. And so if do not track was meant to establish a preference that laws might come along in the future to enforce, GPC is kind of the opposite. There's at least a growing interest in laws that require publishers and ad tech vendors and related parties and websites to respect user preferences, and GPC hopes to be one way of expressing that or asserting that right.
Yeah. So I would add to that. I think this is great. I think how do not track is different from GPC. It's really not so much like maybe as Pete said, a technological level, but more what is outside actually happening. And what is outside is that do not track was based on the California Online Privacy Protection Act. It's a law that happened maybe 15 years ago, and it said you have to say in your privacy policy how you respond to DNT signals. Note, you have to only say how you respond. You don't actually have to respect it. So you can say in very nice words that you don't respect it, and that is what most websites are actually doing. Now with GPC, we actually have in the regulations saying you need to respect it. It's no longer enough to just say, okay, it's nice that you send it, but sorry, we are not able to, honor your signal for X reason. Now you actually have to do it. And so that is a big difference. And I think, if I can maybe also kind of put Robin on the spot here, I think, Robin provided the great, explanation because, the global actually does have a meaning in GPC. I think, the way we see it is that GPC is at the beginning for the CCPA, but we also intend to actually make it work for other laws as well. And so that's why I mentioned Robin, because Robin had a great, interpretation of what GPC can mean in the GDPR context, right? And so that is very different from DNT. DNT was purely based on California law, a very weak law, and global privacy control is actually, global. That's, what we intend to have it. And so maybe Robin, if you want to maybe explain a little bit of your great interpretation,
Sure, and thank you for your kind words. I mean, I'll try not to make a hash of this as a non-lawyer, but essentially at heart, the idea of GPC is that you want the only party that can decide what to do with your data, with the data it observes on the site, to be the first party, right? So basically, you go to a site, it's that site, you have rights with that site, and you might be comfortable in that interaction. That site might delegate some of its processing to other parties, but it's only parties that work for that site. And so basically the core idea of GPC is that it implements sole controllership. There's only one data controller. There's only one controller that can independently process your data. And that means there's a translation, worldwide of this notion of do not sell. In California, do not sell is the way you do sole controllership for Californians. There's a New York law that also has a do not sell provision. It might work the same way in the close future. And under the GDPR, what you do is you are through GPC expressing your data rights, and those data rights can be extremely specific and extremely precise in what they mean. And so you're telling that site, the first party, that if they use consent to share your data to third-party data controllers, then you're withdrawing your consent for that. And if they use what is known as legitimate interest as the legal basis to do that, then you object to that. Both withdrawal and objection are GDPR mechanisms. And so essentially GPC is an abstract notion that has concrete implementation in multiple jurisdictions. And one of the values of having an interpretation under the GDPR is that there's an increasing number of legislations the world around that have very GDPR-like concepts and GDPR-like constructs. If you want to be precise about it, there's often some important differences, but some of the core mechanisms, like the ones I just described, usually get translated into these national laws. And so if you look at Brazil, the United Arab Emirates, Bermuda, probably soon India, then you're looking at very similar laws and very similar legal regimes. And so that means that if GPC works under the GDPR, it's very likely to work in those as well, or we are likely to find a way of making it work there. We should probably invite Eric to just be the moderator, because he has all the questions.
Those are great questions. So yeah, essentially, the idea is there is this GPC mechanism, and it's it's a communication mechanism, and then depending on local laws, it can mean different things. As Robin said, under the GDPR, it means maybe you object to the processing of data if it's based on legitimate interest, or it means I withdraw my consent if it's based on consent. If it is, in California where the signal is received and applicable, then it means, okay, do not sell, right? And so the convergence of the privacy laws worldwide, this catalyst of the GDPR, realizing the conversion of privacy laws everywhere makes that possible. Just as Robin said, the different laws, I actually, I looked into these different laws, and it's very interesting. I didn't know, Kenya, for example, has a new privacy law. So there are, popping up laws, left and right. And, in the United States, we might also have a federal privacy law, actually, because, there is also this the sense in the air, So if you ask about, okay, what is actually different to do not track, there is a different sense in the air, there is a very different discussion, sometimes it's the way that actually it's not so much about what you do, but when you do it. And so, this is a little bit here as well, there's a right and a wrong time to do certain things. And we have the sense that this is the right time, to do GPC. And one of the things that I'm wondering about, maybe Robin and Pete can say much more actually about this, is okay, we have the privacy rights, we have this new consumer empowerment. The other side actually is now, okay, the businesses, how do they adjust their business models to this new environment, right? Because they kind of interact with each other, right? Both of these things have to go together. We cannot just have very strict privacy laws and then nobody knows anymore, okay, now how do I run my business here, right? I mean, so there needs to be some kind of, interaction between the two. And my sense is also that this is happening in the industry, move to first-party advertising, away from third-party advertising, these kind of things, right? The Brave browser, focused on privacy. Privacy is more important to people. So maybe there you have a different business model. And so I would be interested, what do you think about this, Pete and Robin?
I mean, on the business front, I think I might go even further than that. I think this shift towards privacy and this concerted movement towards greater privacy is a huge opportunity for a lot of businesses. Over the past 10, 20 years, publishers, people who build things on the web, have basically been working under an incrementally difficult regime where we can't operate without selling data to third parties. A lot of them don't give us a choice. They don't give us the option to not do that. And so something like GPC allows us to actually use the law to say, hey, consumers don't want that, and this is enforceable, and therefore we can stop. The problem before was that if you wanted to stop, but you were the only one stopping, you would lose in a competitive market because everyone would shift to those who are more privacy invasive, right? With this generalized better privacy, it sort of raises the tide for everyone, and it makes it a lot easier for us, for instance, at the New York Times, to implement better privacy without being a threat to the business of being a publisher. So that this is really helpful for businesses.
There's only so much we can do from the browser vendor to like intervene on behalf of the user into websites, and so we can block certain scripts, or we can make certain interventions on storage policies, or whatever, a number of technical kind of interventions we can make, but those are difficult and error prone and whatever, comes with a large number of downsides. So the more we can do to kind of have a single way of aligning like web experiences with people's desires, particularly with regards to privacy, I mean, it's better for Brave as a company, it's better for our users, and it particularly puts us at less of an adversarial relationship with the websites that we kind of facilitate users visiting for Brave users. So it seems like there really is a potential for this to be good across the board.
So we have a list of questions that so Eric has 2, and I see a new one. So yeah, that's 3 questions total. So Eric initially asked about whether all these consent boxes that people have fun clicking on in Europe, quite familiar with that, if GPC makes that go away. And the answer is unfortunately not entirely, because under not the GDPR but the e-privacy directive, there is still a need to obtain consent for cookies. Now, you might think that's not the smartest regulation out there, so it's certainly not the one that helps privacy the most, but the GPC does not do anything about that. We don't want to prevent people from being able to use cookies, because cookies are kind of useful for a whole number of things that are perfectly privacy respecting. And so we can't solve the cookie consent issue with GPC. We can, however, make it so that you can click yes to those big TCF boxes that have 300 third parties included, and GPC will do the work of withdrawing the consent afterwards. So it does streamline the consent experience for users, because you can consent and then your browser withdraws the consent for you. And in terms of traction, I mean, I think I don't know if we want to talk about exact numbers, but Brave supports it. The DuckDuckGo browser supports it. There's extensions, so OptMe Out, and I believe a few others by now. We'll have more to announce pretty soon. The New York Times is live in production with GPC support, and we'll be announcing a number of other people following soon, following up pretty soon. Yeah, and yes, that will include other publishers, including ad-driven publishers, not just subscription dominated ones. So yeah, no, we're definitely seeing traction. We're seeing traction with a lot of companies, not just in the privacy space, companies that are like proper publishing businesses. So I think it's looking very promising.
Yeah, consent management platforms, so also privacy tech, companies are interested in that. So it is, I think it is very engaging, environment, very dynamic, a lot of things going on. And then we also have maybe, a little bit related Lourdes' question on this. Okay, have we heard from the California AG on whether they are requiring GPC as part of the CCPA and CPRA regs? And so maybe to give a little bit of background to that, the CPRA, which was adopted in November of last year, right, includes additional provisions for privacy in California. And one of these provisions is that the California Attorney General has to specify really the technical specification. Okay, how do you send these signals? Or should say, okay, this is how we imagine how this signal should look like. And the CPRA will become effective in about 2 years. And so, by that, we certainly will have some kind of signal that says, okay, this is what is, this is how that looks like and how browsers can send that, and publishers and others must respect that. And so that is a process, that is ongoing. So we received maybe if you follow this, like an initial comment from the California Attorney General on GPC, who said, okay, this is a good initial effort, and he was heartened to see that the tech and ad community and privacy community is picking up on this. And so I would say it seems to me that this is a process. So I would say look out, for the news, on that. We are certainly always, updating our website, on all kinds of developments, but it will probably not be the way that immediately we can declare victory. That is a longer process. I would say that is a little bit the general gist of this.
And I would add in general that it's not just the California Attorney General that we're looking forward to hearing from. We're in discussions with a number of other regulators, and so far the feedback is positive. I'm not going to commit on behalf of anyone at this point, but so far people like it, and so I hope to see an increasing number of formal backing. As we
were particularly pleased by the Privacy Commissioner of Bermuda, and we hope very much that he will extend his engagement, so that we have an opportunity to also personally see how actually it works in Bermuda. This is our most in our minds and concerns at the moment.
I mean, people joke about that, but Bermuda has PIPA, which is a GDPR-like regime, and so the fact that the Privacy Commissioner of Bermuda, who's a specialist on this topic, finds it applicable is actually a very, very positive signal.
Absolutely, well. It's such a great thing that he did this, that he put out this information, and we are very grateful for any regulator who makes these kind of statements. Absolutely.
Yeah, no, since it's on topic, I was going to jump on Eric's question as well. Yes, we are working with European regulators. As you know, the situation in Europe is less unified than we'd like. We were promised this GDPR regime that would solve all the things for everyone in Europe at once, and it's a lot more fragmented from DPA to DPA. Yeah. But we're talking with some DPAs and people there, and I have hope that we can make some progress. So far, again, feedback is pretty positive. We haven't spoken with the Norwegian DPA. They've been making some pretty good decisions lately. So happy for introductions to go talk to the folks there as well.
Just wanted to add one more note on Eric's question about consent dialogues and GPC's connection to them. I mean, I think just to second what was said before, GPC doesn't directly relate to those things, but we've had a number of communications or conversations both in standards and just with Brave with other consent vendors about using GPC as a model for a broader set of possible features that would, in a GPC-like way, allow expressing consent in a standardized way that would use GPC as a building block to kind of deal with these other kind of internet annoyances.
Yeah, I would also point out, I would like to extend this idea that Pete just said. At the moment we're talking about the web, and we're talking about different countries. But I can think of many different ways of extending GPC. So first, this could be for mobile apps or other types of online services beyond the web, right? Because there is data collection happening there too. And so in principle, there could be something like GPC or even GPC extended or GPC plus, in these kind of environments as well. And secondly, at the moment, we are focusing on do not sell, do not share, but there are other privacy rights as well. So there are rights, to claim the deletion of your data, or, the right to access to your data, all these, other rights. And you can imagine, okay, once you have established such a communication platform, that there's maybe an option to extend it, towards these additional rights. And so, if we look very far in the future, that could be an option here as well. And the reason why we started with the do not sell right is because we have something very concrete. We have the CCPA that makes a very concrete statement. You need to respect global privacy controls for opting out from the selling of your personal information. And so that is a really concrete point where we can attach our idea to. But if we go forward now, then we can extend that in multiple directions. And that is our plan going forward. Okay, there is another question.
We could handle TCF, but not necessarily cookies. Yeah, I mean, essentially, using TCF, you can signal two things. You can signal legitimate interest and consent for each vendor. Normally, GPC just like removes both. So it does intervene at the TCF level. I also believe, I think Aram Zakoshoff from WAPO, who's been working with us on the GPC group, has written some code that checks to see if there's a GPC signal and actually sends the right US TCF opt-out for CCPA to make sure that it's fully integrated with the TCF. So yeah, there's definitely a bridge there. And at some point, it's entirely possible that we'll work with the IAB to see how to push GPC into those pipes as well.
Yeah, there are different there are different ways of thinking about this, and I want to mention also one additional feature that I often get asked about when I talk about GPC, and that is when I mention GPC to users, they then ask, okay, I'm going to send a signal, but how do I know they respect it? Or what happens with that, right? And so for that, GPC actually also has a mechanism. And we base that on the .well-known specification. And so that essentially means that if you are a publisher or other website that wants to engage with GPC, you can have a website, a resource on your site under a .well-known domain. So it is the same place for all the websites. It is .well-known /gpc.json. So it's a JSON file. And there you can express that you respect GPC. And so every browser or browser vendor can now go to the site and check, okay, what does the site do here? Do they have a .well-known site? And then retrieve this JSON file and then surface the result to the user. At the moment, I think we have three possibilities here. Either it is respected or it is not respected. For example, because of fraud suspected. There's essentially the only reason I can think of if all the other requirements are satisfied, or if a site doesn't participate, then they don't have it. But the main point I think is that you have a response mechanism. So that the user knows what happened to the signal.
Is this on nytimes.com now? So I haven't added the gpc.json resource, but I will. Actually, the pull request is open, so it'll land at some point. The other side of GPC, which is respecting the signal, is live on NY Times. And yeah, we respect it in California, Europe, Brazil, UAE, a bunch of other places. So yeah, it's there. You won't see, in terms of user experience, you won't see a huge difference. It's it basically keeps the same user experience. We can still show. I mean, one of the reasons why this is good for publishers, right, is that we can still show ads so long as they're ads that do not sell your data, and we can still maintain the exact same experience. The only thing that happens is you've automatically expressed your data rights, and it doesn't interfere with any part of the experience, and it doesn't interfere with our ability to run a business. So overall, it's pretty positive on both ends, unless you're a data broker. But,
yeah.
Those are not our constituency.
Yes, I just posted a link to our project site there, so you can find information there. And also, if you wanted to implement it, there are resources how to do that, and you can test it. I particularly like the site because there you actually have a little bit of a visual, right? If you're sending the signal, it tells you, okay, green, fine, you are good. And that is actually very important, I find. Make it somehow, you need to have a good user experience, I think, and to somehow surface that to the user. It's not just that you kind of have to put your faith in that it actually works, but that you see something, right? You see some kind of reaction that it works. I think that's that's very important, and this site here just demonstrate how you could show it to the user that you have received such a signal and that you acknowledge it and that you respect it. So there are ways, to surface, this, respect to the user.
And my understanding is that Kubler doesn't sell data. So, Eric, if you want to go ahead and implement support, like by all means, please do.
Robin, I wonder from a publisher's side of things, if this tracks with what you've heard. So I can think of 3 or 4 different sites that have reached out to Brave saying, we know that your users don't want like cookie dialogues and that you do certain things that will try to just dismiss them on your behalf, and there's some non-trivial chance of them breaking things. Is that part of, does that match your sense of, we wish there was a standardized way of expressing these kinds of, these user preferences that would not drive people to try to like break our site or try to intervene in what we want to do, but at the same time, respect the same kind of output that would come up in those dialogues?
Yeah, I mean, absolutely. In general, as a publisher, and particularly as a publisher that cares about privacy, my biggest fear is that someone will come up with something that makes us do work we shouldn't otherwise be doing in order to respect people, to respect a regulation, to support stuff we already do for our users' privacy. And so for me, like the cookie banner is an example of that, right? We already do as much as we can to push the envelope on respecting people's privacy, but we still have to show them this stupid pop-up that doesn't help them, doesn't help us, and does nothing to protect their rights. And so something, a standard like this, where instead of people having to scroll to the bottom of a page or to find where they need to opt out and to opt out on every site, etc., so that we can then tell the third parties we work with in advertising, hey, you have to opt out this person out. It's not our call. We're using like the law to really push on this. Then it's automated. So for us, it's less work. It's more unified code. New York Times we don't have a huge portfolio of products, but we have like 60, 70 different products that have user surfaces, and we want to have the same privacy experience across the board. So, something where we can just like take a standard, plug it into code that we share across the board, it is a huge win. It's a huge win. And yeah, it's, one thing that's difficult is when there's this cat and mouse game that you were describing, where browsers come up with a new way of blocking something, and then the vendors that are on the site try to figure out a new way of like working around it, and we're in the middle, and we don't control all the scripts that run in ads and stuff like that, right? And so you end up with some vendors I won't name doing crazy things, trying to fire up WebRTC to get some fingerprinting surface inside of an ad and things like that, and all of a sudden your site is burning. You get some random pages crashing, no one knows why. So yeah, absolutely. Standardizing privacy helps.
And I just posted here, if you're interested in the standard discussions, please join us at the W3C. There is a privacy community group where we discuss this. And, we sometimes also have these breakout meetings where we specifically discuss, GPC, and our goal is in the end to have a standard for GPC at the W3C, and that's what we're working towards. I wanted to mention one other point. For example, if you use Brave now, right, there's actually nothing you need to do, right? You send the GPC signal automatically, and it is already in the production version. And so this is great. But GPC also allows, if you don't want to send it to all websites, you can actually choose also the websites to which you want to send those. So there are different possibilities of implementing GPC. And I know, Peter, it was very important, I think, to Brave to not have any additional fingerprinting surface, right? And so if you have the general GPC, you send it for all your users, you send it to all your website, right? There is no additional fingerprinting surface. So you can also play a little bit around with that, right? Depending on who you are. Maybe if you develop an extension, maybe you want to make it more nuanced. If you're a browser vendor, then maybe not. So GPC has that flexibility.
You said it better than me. One thing that's important is to not allow users, like not have some kind of unintended side effect of users being more identifiable by participating in the system. And so there's aspects of the standard that say if you think your users are, by virtue of using your product or your tool, expressing a privacy interest already, then you don't need to have this configurability. I think that's very respectful of users and an important part of making sure that it's strictly more privacy preserving and not some kind of trade-off.
Absolutely, yeah. So the California Attorney General said that if you are picking a privacy preserving product like Brave, you already expressed your intention that you want to send the GPC signal by default. And so that's a valid, choice.
Of course, I mean, if you ask users, they all expect that when they pick up a browser, it's privacy preserving. So, I mean, and in polling, it's extremely strong. It's like, 90% of people expect their browser to simply not share data to any third party whatsoever. So I would make the case that when people use a browser, they expect GPC to be on anyway. But I don't know if that'll hold up in court.
I like Eric's idea of this virtuous cycle, though, of GPC support being a distinguisher on publishers. I'm all for that.
I mean, I'd float the idea, but the chances I have of convincing our excellent product people of putting a 3-letter acronym, I don't know, at the top next to the New York Times logo, I think pretty slim.
Well, maybe just the button. Yeah. So okay, I think originally I think our session was scheduled for 45 minutes, right? So I mean, we can stick around, or if there are more questions, we can answer that. But we're also happy to. To call it a day. So
yep. Send us, don't hesitate to reach out, in email, on Twitter. We're pretty easy to find, I think, all three of us. And we're happy to continue these discussions.
Yeah. Okay. Great. Then very good. Interacting with you and see you around, right? Guys. And hopefully many of you around. Okay.
Thanks, everyone.
Bye-bye.
See you. Take care, everyone. Take care.